Okay, let's unpack this. Have you ever paused to think about the fundamental structures that truly govern our states in India? Today, we're embarking on a deep dive into some of the most crucial articles of the Constitution of India, specifically Articles 190 to 231. These aren't just dry legal texts, they are the constitutional bedrock for our state legislatures and high courts, essentially, the blueprint for how state level laws are crafted, how our elected representatives are held accountable, and how justice is administered across the states. It's a dense, yes, but incredibly rewarding journey into the very heart of India's state level governance and judicial system.
Indeed. Our mission with this deep dive is to distill the most important nuggets from these articles. We want to help you understand not just what these laws say, but why they matter so profoundly, uncover some surprising facts, and place them within their broader context. We'll explore everything from the foundational rules of who can be a legislator, under what conditions they might vacate their seat, to the intricate process of how laws are passed, the governor's often underestimated yet vital role, and the expansive guardian-like powers of the high courts, including their unique position as protectors of justice and the Constitution itself. Prepare for those aha moments as you gain a much clearer picture of how power truly operates at the state level.
Exactly. This isn't about getting bogged down in legal jargon. It's about gaining a powerful understanding of the mechanisms that directly influence policy, public life, and your fundamental rights within your own state. So settle in, grab your favorite beverage, because we're about to become exceptionally well-informed on a topic that truly shapes the daily lives of millions. We're going to begin our exploration right at the very foundation of state legislative bodies, who gets to be a member, and under what conditions they might cease to be one. It's a vital starting point for maintaining the integrity of our representation.
Absolutely. We kick off with Article 190, which focuses on the vacation of seats. This article spells out the various conditions under which a member of a state legislature, that's an MLA, a member of the Legislative Assembly or an MLC, a member of the Legislative Council might have their seat declared vacant. The core idea here is to ensure focused and single representation, preventing individuals from holding multiple, potentially conflicting legislative roles.
That sounds absolutely crucial for accountability and clarity. So let's dig into these conditions. The first one, in Clause 1, talks about no dual membership within the same state legislature. What does that mean for an individual?
Right. Clause 1 is quite clear. A person simply cannot be a member of both the Legislative Assembly and the Legislative Council of the same state at the same time. The reason for this is, well, practical and profound. It ensures a legislator's undivided focus on one chamber's duties, preventing conflicts of interest or a dilution of their legislative attention. The state legislature itself has the power to make laws detailing how a person makes this choice. For example, if someone is an MLC and then gets elected as an MLA in the same state, they must choose which seat to keep within a stipulated period as per state law. If they don't choose, well, their seat in one house or the other will automatically become vacant. It's a direct mechanism to enforce that dedicated, single-minded representation.
Okay, that makes sense. And it gets even broader with Clause 2, which says you can't be a member of legislatures of multiple different states. This really underlines that idea of focused loyalty, doesn't it?
It definitely does. Clause 2 is designed to prevent an individual from spreading their representative duties too thinly by trying to serve citizens in two or more different states. This is a fundamental principle ensuring a legislator's loyalty and attention are confined to a single state. To make this operational, the President has issued specific rules, known as the Prohibition of Simultaneous Membership Rules of 1950, which specify a period within which such a person must resign from all but one state legislature. Fail to do so, and their seats in all such states become vacant. It's a very strong deterrent against divided loyalties and commitment.
So we've covered dual membership within the state and across states. But what about a seat becoming vacant because of disqualification or resignation? That falls under Clause 3.
Precisely. Clause 3 outlines two primary triggers. First, under subclause A seat becomes vacant if a member incurs any disqualification listed in Article 191, which deals with criteria like holding an office of profit or being of unsound mind, or Article 191, which refers to disqualification due to defection under the 10th schedule. This provides a direct and immediate consequence for not meeting the ongoing eligibility criteria.
And then there's the resignation part in Clause 3B. This is where it gets really interesting because there's a crucial safeguard added by the 33rd Amendment. It says the Speaker or Chairman of the House can actually inquire into the voluntariness and genuineness of a resignation. If they're not satisfied, they shall not accept it. What was the thinking behind adding such a powerful proviso?
That proviso is an incredibly vital safeguard, especially given the dynamics of Indian politics. Think back to periods of intense political turmoil where members might be pressured or, coerced or even outright forced to resign. Such actions could fundamentally undermine democratic functioning, facilitate political maneuvering like government collapses, or enable unethical party switching. This provision grants the Speaker or Chairman a crucial quasi-judicial role. They aren't just a rubber stamp, they can investigate. For instance, if an MLA submits a resignation letter amidst a tense political crisis, the Speaker can investigate, gather evidence, and if they find coercion, they can refuse to accept the resignation. This protects that member's mandate and, by extension, the integrity of the House itself.
That's a significant check on political manipulation. Wow. Lastly, Clause 4 deals with vacation due to absence. How does this work to ensure active participation?
Clause 4 states that if a member is absent from all meetings of the House for a period of 60 days without obtaining permission, the House may declare their seat vacant. It's important to note a nuance here. The 60-day period specifically excludes any time during which the House is prorogued, meaning the session has been formally ended or adjourned for more than 4 consecutive days. This provision aims to ensure active participation and accountability from our elected representatives. It's not an automatic vacation, mind you. The House declares it, which means there's room for consideration of, valid reasons for absence. As an illustration, if an MLC is continuously absent for over 60 days without seeking permission, the Legislative Council can then pass a motion to declare their seat vacant, enforcing their duty to attend to legislative business.
So pulling all this together, Article 190 really emphasizes representative accountability and single representation focus, making sure that those we elect are fully dedicated and active in their roles. I imagine these principles apply not just to state legislatures, but also at the national level for members of parliament, right? And cases under the 10th schedule, our anti-defection law, must often trigger these provisions.
You've made a crucial connection there. These foundational principles of representative accountability and single representation focus are indeed central to maintaining integrity in our legislative bodies. And yes, principles analogous to Parliament, especially those under Article 101, certainly apply. The 10th schedule, our anti-defection law, is a prime example of legislation that directly leads to disqualification and consequently the vacation of seats under Article 193, read with Article 191. It's all part of the overarching system designed to maintain legislative purity. Now let's move on to Article 191, which dives into the specific disqualifications for membership, the very conditions that uphold legislative integrity. This article mirrors Article 102 for Parliament, maintaining consistency in ethical and legal standards for all legislators.
Right. So what are these grounds for disqualification under Clause 1? The first one, holding office of profit, always seems to spark a lot of debate.
It's a cornerstone of legislative independence, Clause 1A. If a person holds an office of profit under either the government of India or any state government, they're disqualified. The rationale is to maintain the independence of legislators from executive influence, preventing them from being beholden to the executive for financial gain outside their legislative duties. A fascinating aspect here is that state legislatures themselves have the power by law to declare certain offices not to disqualify their holders. This leads to state-specific prevention of disqualification acts, balancing the need for independence with, the practicalities of governance. It's important to note that being a union or state minister is explicitly not considered holding an office of profit for this purpose. The Supreme Court, in landmark cases like Jayabakshan versus Union of India, clarified that office of profit isn't just about actually receiving profit, but the capability of the office to yield profit. So if an MLA is appointed as, say, a managing director of a state government-owned corporation with remuneration, and that specific office hasn't been exempted by law, they could face disqualification.
Okay, so it's about preventing potential conflicts of interest, ensuring legislators aren't serving two masters, so to speak. What are the other clear, objective grounds for disqualification?
Beyond the office of profit, Clause 1 outlines several other clear grounds. Subclause B disqualifies a person if they are of unsound mind and stand so declared by a competent court. Pretty straightforward. Subclause C deals with financial solvency, disqualifying an undischarged insolvent. Then D relates to citizenship and allegiance. Not being an Indian citizen, voluntarily acquiring foreign citizenship, or acknowledging allegiance to a foreign state. Imagine an MLA discovered to have acquired, say, Australian citizenship. Before contesting, they would be disqualified under this. Lastly, subclause E is a broad category encompassing disqualification by or under any law made by Parliament. This prominently includes the Representation of the People Act, 1951, which covers convictions for certain offenses or corrupt electoral practices. This provision ensures a degree of uniformity in some disqualifications across states, dictated by a central law. For instance, an MLA convicted of a serious offense under the RPA and sentenced to 2 years imprisonment would face disqualification.
And then there's Clause 2, covering the crucial issue of defection. This was a significant addition, wasn't it? Part of the anti-defection efforts.
Absolutely. Clause 2, inserted by the 52nd Amendment, directly states that a person is disqualified if they are so disqualified under the 10th schedule, which is our anti-defection law. This was introduced specifically to curb political instability, party hopping, and the unethical practice known as horse trading, ensuring some party discipline. The landmark case of Kyoto Hallhan versus Zakilu upheld the validity of the anti-defection law, clarifying that while the Speaker's decision on defection is crucial, it is subject to limited judicial review. So if an MLA defects from their party, defying the party whip, they face disqualification under the 10th schedule, as per Article 1-1-2. These disqualifications, incidentally, apply both for being chosen at election time and for continuing as a member. It collectively ensures the purity and integrity of legislatures and the independence of legislators from executive control.
So we've established the grounds for disqualification. But who actually decides on these questions? That's where Article 192 comes in, focusing on the decision on disqualifications. I understand the governor plays a role, but with a critical caveat involving the Election Commission.
That's right. The core concept here is that the governor is indeed the final authority to decide questions of disqualification under Article 191, but, and this is the crucial part, only on the binding opinion of the Election Commission. This mirrors Article 103 for members of Parliament, emphasizing an impartial, expert-driven decision. It's vital to note that Article 192 applies only to disqualifications of a sitting member under Article 191, issues like office of profit, unsound mind, insolvency, citizenship, or disqualification under parliamentary law. It does not apply to pre-election disqualifications, which are handled through election petitions, nor does it apply to disqualifications under the 10th schedule for defection. Those are decided by the Speaker or Chairman of the respective House, a very important distinction.
Okay, so while the decision is formally the governor's, it's not their personal discretion, is it? The EC's opinion is binding.
Not at all. Clause 1 states that the question is referred to the governor, whose decision shall be final. However, Clause 2 mandates that the governor must obtain the Election Commission's opinion before making any decision. And significantly, the governor shall act according to such opinion. The nuance here is quite fascinating. While the decision is formally pronounced by the governor, it's effectively the Election Commission's. The governor acts as a constitutional authority, not exercising personal discretion, thereby ensuring impartiality and taking the decision out of the purely political realm. The EC itself acts in a quasi-judicial capacity, expected to follow principles of natural justice, such as giving the concerned member a fair hearing. Even though the decision is declared final, it's not entirely immune. It is still subject to limited judicial review on grounds like a flawed process or a, perverse opinion. This mechanism truly ensures that decisions on disqualification are based on the binding nature of expert constitutional bodies' opinion, promoting fairness and impartiality, as reiterated in cases like Election Commission of India versus Saka Venkata Rao.
That structured process certainly adds a layer of robustness. Next, we have Article 193, which imposes a penalty for improper sitting and voting. This sounds like a deterrent for unauthorized participation.
It is exactly that. The core concept here is to impose a monetary penalty to deter individuals from improperly participating in state legislature proceedings, mirroring Article 104 for Parliament. The penalty kicks in if a person sits or votes under several conditions: before taking the oath required by Article 188, or if they do so knowing they are not qualified, or knowing they are disqualified, or if they are prohibited by law from doing so. The liability is a penalty of 500 rupees for each day of such improper sitting or voting, recoverable as a debt due to the state. While seemingly a small sum in today's terms, this monetary penalty acts as a deterrent, reinforcing the seriousness of complying with constitutional prerequisites for legislative membership. The knowledge element, or mens rea as lawyers call it, meaning a guilty mind, is crucial here. It differentiates an honest mistake from a deliberate violation.
Got it. So if a newly elected MLA, for example, jumps the gun and participates in a debate and votes before formally taking the oath, they would be liable for Rs. 500 for each day of that participation. It's a direct and clear consequence then. Now that we've thoroughly covered who can be a member and how they are held accountable, let's pivot to explore the actual powers they wield and how the crucial financial business of a state is conducted.
Right. This brings us to Article 194, which details the powers, privileges, etc. of state legislatures and members. This article is foundational to ensuring their independent functioning. The core concept is to safeguard the independence and effectiveness of state legislatures by granting their houses, members, and committees certain essential powers, privileges, and immunities, mirroring Article 105 for Parliament.
The first, and arguably most fundamental aspect here, is freedom of speech within the legislature, as per Clause 1. That's absolutely critical for any democratic body, isn't it?
It is the bedrock. Clause 1 guarantees freedom of speech within the state legislature. This freedom, however, is subject to constitutional provisions, such as Article 211, which restricts discussion on judges' conduct and the House's own rules. This freedom is then robustly buttressed by Clause 2, which grants absolute immunity from court proceedings. A member cannot be held liable for anything said or any vote given within the legislature or its committees. The same absolute immunity applies to official publications made by or under the authority of the House. This is vital for robust debate and scrutiny, allowing a legislator to speak freely and critically without fear of defamation suits for statements made inside the House. For example, if an MLA makes critical allegations against a public official during an assembly session, they cannot be sued for defamation for those specific statements made within the House.
That makes perfect sense for encouraging open and unfettered debate. But what about other powers, privileges, and immunities mentioned in Clause 3? That seems a bit more open-ended, and I hear it has led to some interesting historical situations.
That's where it gets particularly nuanced and often quite complicated. Clause 3 states, these other powers and privileges are to be defined by the state legislature by law. But here's the fascinating part. Until they are so defined, and most state legislatures, surprisingly, haven't fully codified these, to this day, they are those that existed for the House, its members, and committees before the 44th Amendment. This effectively means they revert to the powers and privileges of the UK House of Commons at the commencement of the Indian Constitution. This reliance on historical, uncodified privileges has, at times, led to considerable uncertainty and occasional conflicts with citizens' fundamental rights, prompting court interventions. These other privileges can include things like freedom from arrest in civil cases during sessions, the right of the House to regulate its internal proceedings, exclude strangers from its debates, and even punish for breach of privilege or contempt of the House.
So it's a bit of a historical legacy that continues to shape modern legislative practice, leading to those landmark cases like Keshav Singh versus Speaker, Legislative Assembly. That case highlighted the tension between legislative privileges and fundamental rights, asserting that privileges are not absolute. And more recently, the Supreme Court in State of Kerala versus K. Ajith clarified limits, stating legislative privilege cannot shield criminal acts like vandalism within the House, because those aren't essential legislative functions.
Exactly. Those cases are crucial in understanding the practical boundaries and the ongoing evolution of these powers. Finally, Clause 4 extends these privileges to state ministers and the Advocate General for the state, who, by virtue of Article 177, have the right to speak in the legislature even if they aren't elected members. So, at its heart, this article is about freedom of legislative deliberation and internal autonomy of legislatures, ensuring they can function effectively without fear or external interference.
Next up, Article 195, which covers salaries and allowances of members, essentially fair compensation for public service. This seems pretty straightforward.
It is indeed. This article empowers the state legislature to determine the salaries and allowances for its own members, both MLAs and MLCs, through legislation. It's a clear entitlement. Members of both houses are to receive salaries and allowances. The specific amounts and conditions are determined by an act passed by the respective state legislature. Until such a law was made, the salaries and allowances were based on those applicable to the corresponding province before the Constitution. This reflects state legislative autonomy in financial matters concerning its members, which is precisely why the salaries of MLAs and MLCs vary significantly across different states. While it's sometimes debated as a potential conflict of interest, it's a common feature in many democracies, with the expectation that such decisions are subject to public scrutiny. For instance, the Legislative Assembly of a state passes an act to revise the monthly salaries and allowances for its MLAs. This is a direct exercise of power under Article 195.
Now that we've covered compensation, let's look at how laws are actually made. Article 196 outlines the provisions as to introduction and passing of bills, describing the legislative journey for ordinary bills.
This article outlines the general legislative process for ordinary bills, meaning non-money bills and non-financial bills in state legislatures, closely mirroring Article 107 for Parliament. Clause 1 specifies that in states with a legislative council, ordinary bills can originate in either house, except for money bills, which are handled by Article 198, and certain financial bills under Article 207.
And once a bill originates, how does it get passed in a bicameral legislature? Does it need agreement from both houses?
Yes, Clause 2 states that a bill isn't deemed passed unless it's agreed to by both houses, either without amendment or with amendments agreed to by both. However, Clause 3 notes that a bill pending in the legislature does not lapse just because the session ends due to prorogation. It can be taken up again in the next session. The more critical distinction, and a really important one for understanding legislative continuity, comes with the dissolution of the Legislative Assembly.
Right. So what exactly happens to pending bills if the Legislative Assembly dissolves? That sounds like it could significantly disrupt legislative progress.
It's a very critical aspect found in Clauses 4 and 5. Bills that do not lapse, as per Clause 4, include those pending in the Legislative Council that have not yet been passed by the Legislative Assembly. These survive dissolution. However, bills that do lapse, under Clause 5, are those pending in the Legislative Assembly itself, or those that have been passed by the Legislative Assembly and are currently pending in the Legislative Council. This distinction highlights the primacy of the Legislative Assembly in a bicameral setup. When the Assembly, which represents the direct and current will of the people, dissolves, most bills associated with it lapse. This allows a newly elected Assembly to consider matters afresh without being bound by the previous session's legislative efforts. The Purushothaman Nambudiri versus Estate of Kerala case extensively discussed and clarified the lapsing of bills under Article 119.6.5. So this article really defines bicameralism and legislative process at state level, and the principle of continuity of legislative business, albeit with crucial caveats for Assembly dissolution.
That's a clear delineation of power. Following on, Article 197 focuses on restriction on powers of legislative council as to bills other than money bills. This suggests the council's power over ordinary legislation is quite limited, doesn't it?
It significantly curtails it, yes. The core concept here is establishing the Legislative Assembly's ultimate supremacy over the Legislative Council for ordinary legislation. The Council can delay an ordinary bill, but cannot ultimately veto it. Clause 1 specifies that if the Assembly passes a bill and sends it to the Council, and the Council either rejects it or doesn't pass it within 3 months or passes it with amendments the Assembly disagrees with, well, then the Assembly can pass the bill again and retransmit it.
Okay, and what happens after that second transmission to the council? Can they still block it indefinitely then?
Not at all. Clause 2 makes it clear. If, after the second transmission, the Council again rejects it, or doesn't pass it within 1 month, or passes it with amendments the Assembly disagrees with, then the bill is deemed to have been passed by the houses of the legislature of the state, in the exact form the Assembly passed it the second time. What's truly striking here is that the Council's power is limited to a maximum delay of about 4 months. That's 3 months initially, plus 1 month after retransmission. And there's no provision for a joint sitting at the state level, unlike Parliament's Article 108, which offers a mechanism to resolve deadlocks. This starkly highlights the supremacy of the lower house in state bicameralism and clearly defines the Council's role as primarily a revising and delaying chamber, rather than an equal partner in ordinary lawmaking. For example, if the Assembly passes an education bill and the Council rejects it, the Assembly passes again. If the Council then takes 45 days to consider it and suggests more amendments the Assembly rejects, the bill is then deemed passed in the form the Assembly passed it the second time. And Clause 3 explicitly states that this procedure does not apply to money bills.
Right, which leads us directly to Article 198, special procedure in respect of money bills. This is where the Assembly's financial supremacy becomes absolutely undeniable, right?
Absolutely. This article lays down a special and expedited procedure for money bills, severely limiting the Legislative Council's powers and unequivocally ensuring the Legislative Assembly's supremacy in financial matters, mirroring Article 109 for Parliament. Clause 1 unequivocally states that money bills cannot be introduced in the Legislative Council. They must originate only in the Legislative Assembly.
So once the Assembly passes a money bill, what little role does the Council then have in the process? Just recommendations.
A very, very limited one. Under Clause 2, after Assembly passage, the money bill is transmitted to the Council merely for recommendations. The Council is given a strict limit of 14 days to return the bill with any recommendations it might have. It cannot reject the bill entirely, nor can it amend it directly. Its power is confined solely to suggesting recommendations. Then, under Clauses 2, 3, and 4, the Assembly has complete discretion. It can choose to accept or reject all or any of those recommendations. If accepted, the bill is passed with those accepted amendments. If rejected, it's passed to the Assembly's original form. Clause 5 delivers the final blow, really. If the council doesn't return the bill within the 14-day window, it's deemed passed by both houses and the exact form the assembly passed it. This clearly establishes the financial supremacy of the directly elected House at the state level, upholding the democratic principle of no taxation without representation by ensuring that the body directly accountable to the electorate controls public finances. For instance, if the state appropriation bill, a clear money bill, is passed by the assembly, and the council suggests some changes, the assembly can simply reject all of them, and the bill is still deemed passed by both houses in the assembly's original form.
And to leave no room for ambiguity, Article 199 provides a precise definition of money bills. What exactly qualifies as financial legislation under this article? What has to be in it? Or maybe what can't be in it?
Good question. Article 199 provides an exhaustive definition of a state-level money bill, mirroring Article 110 for Parliament. The core concept is that for a bill to qualify as a money bill, it must exclusively deal with specific financial matters outlined in Clause 1. These include aspects like the imposition, abolition, remission, alteration, or regulation of any state tax, the regulation of the borrowing of money or giving of any guarantee by the state government, the custody or transactions of the state's consolidated fund or contingency fund, the appropriation of money from the state consolidated fund, declaring any expenditure to be charged on the state consolidated fund, or the receipt, custody, or issue of state public money or matters incidental to these. The word only in Clause 1 is absolutely critical. If a bill contains any other substantive non-financial provisions, it's not a money bill, even if some of its clauses have financial implications.
Okay. And what's specifically excluded from being classified as a money bill to avoid overreach? Things like fines or local taxes?
Exactly. Clause 2 clarifies that a bill is not a money bill, merely because it includes provisions related to fines, pecuniary penalties, the demand or payment of fees for licenses or services rendered, or the imposition, abolition, remission, alteration, or regulation of any tax by any local authority or body for local purposes. This prevents every bill with a minor financial component from being treated as a money bill. Now, a truly critical point. If any question arises about whether a bill is a money bill, the Speaker of the Legislative Assembly's decision shall be final, according to Clause 3. This is designed to prevent inter-house disputes and ensure efficiency in the legislative process. Clause 4 also mandates the Speaker's certificate on every money bill when it's transmitted to the Council or presented to the Governor for assent. While the Speaker's decision is generally conclusive, the Supreme Court, in judgments analogous to the Adhar judgment at the union level, has suggested that this conclusiveness implies limited judicial review if the decision is patently erroneous or made in bad faith or malafide. So while the state's annual appropriation bill is a clear money bill, a bill that reforms municipal governance but also includes provisions for municipalities to levy fees for services, is not a money bill just because of those fee provisions.
Okay, got it. From the Assembly's power to pass money bills, we move to Article 200, which covers assent to bills and outlines the governor's gatekeeping role. This is the penultimate step for any bill to become law, right?
Yes, the governor's assent is absolutely necessary for a state legislature bill to become an act. Once a bill has been passed by the legislature, it's presented to the governor, who then has several options. They can simply give assent, at which point the bill becomes an act. Straightforward. Or they can withhold assent, meaning the bill does not become law. This is effectively an absolute veto, though typically exercised on the advice of the State Council of Ministers. A third option, for non-money bills only, is to return it for reconsideration. This is a suspensive veto. The governor may return it as soon as possible with a message requesting reconsideration or suggesting amendments. If the legislature passes it again, with or without amendments, and presents it back to the governor shall not withhold assent therefrom. This means the legislature can override the governor's suspensive veto.
But the governor also has the power to reserve a bill for the president's consideration. And there's a mandatory scenario for this reservation, isn't there? Something about protecting the high court.
Indeed. The governor may reserve any bill for the president's consideration. This action is then governed by Article 201. But here's where it gets really interesting and highlights a critical safeguard. The second proviso to Clause 1 states that the governor shall not assent to, but shall reserve any bill which, in the governor's opinion, would derogate from the powers of the High Court so as to endanger its constitutional position. This is a crucial non-negotiable safeguard for the protection of judicial independence at the state level. While the governor generally acts on the advice of the State Council of Ministers, this power to reserve a bill, especially under the second proviso, often involves discretion or acting as a conduit for union supervision. A contentious point that has often been debated is the lack of a specific time limit for the governor to act on a bill, which could potentially lead to a pocket veto at the state level, where a bill simply sits without assent or action. The Shamsher Singh versus State of Punjab case established that the governor typically acts on ministerial advice. But cases like Hochist Pharmaceuticals Ltd. Versus State of Bihar discuss the intricacies of reservation for the president, particularly for concurrent list matters. This provision is a significant checks and balances state-union mechanism.
That's a fascinating layer of scrutiny and a vital protection for the judiciary. Then, following on from that, Article 201 covers bills reserved for consideration and illuminates the president's ultimate role in state legislation. What happens once a state bill reaches the president?
Once a state bill is reserved by the governor under Article 200, the president also has a set of options. They can either give assent, at which point the bill becomes law, or withhold assent, in which case the bill fails to become law. However, if the bill is not a money bill, the president may direct the governor to return it to the state legislature with a message for reconsideration, similar to the governor's suspensive veto. The state legislature must then reconsider it within a period of 6 months.
Okay, so if the state legislature repasses it after reconsideration, is the president then obliged to assent, much like the governor's situation with the return bill?
No, and this is precisely where it's quite different, and a point that highlights the unique nature of our federalism. What's fascinating here is that, unlike the governor, Article 201 does not oblige the president to assent to a reconsidered bill. The president retains the power to withhold assent even after the state legislature repasses it. This grants the union executive a significant, and in many ways, absolute veto over certain state legislations. It reflects a key aspect of our federalism with unitary features and demonstrating a measure of union control over state legislation, limited. The president, in this context, acts on the advice of the Union Council of Ministers. For instance, if the governor reserves a bill from a state legislature concerning a concurrent list subject that the union government believes contradicts national policy, the president, on the union government's advice, can withhold assent and the bill ultimately fails. The Hochist Pharmaceuticals Ltd. Versus State of Bihar case specifically explained how presidential assent under Article 201 can cure repugnancy with union laws for concurrent list subjects, as outlined in Article 254-2.
From the broader legislative process, let's now zero in on the financial heartbeat of any state, its annual budget, and how public money is managed and authorized.
Right. This brings us to Article 202, the annual financial statement, which is essentially the state budget. The core concept here is that it mandates the annual presentation of the state budget, detailing estimated receipts and expenditure to the state legislature. A key feature is its distinction between votable and non-votable or charged expenditure, mirroring Article 112 for the Union.
So the governor causes the statement to be laid before the House. What are the key contents, especially regarding charged expenditure, and why is that distinction important? Is it about independence?
Indeed. Clause 1 outlines the governor's duty to cause the annual financial statement to be laid before the houses of the legislature. Clause 2 details that the estimates of expenditure must separately show charged expenditure, which is non-votable, and other expenditure, which comprises the votable demands for grants. It also distinguishes between revenue and capital expenditure. Clause 3 then lists specific items that are charged on the consolidated fund of each state. These are constitutionally mandated expenses that are not subject to the vote of the Legislative Assembly, although they can be discussed. Examples include the governor's emoluments, salaries of presiding officers of the state legislature, state debt charges, salaries and allowances of high court judges, sums needed to satisfy court decrees, and other items declared by the Constitution or state law to be so charged. This provision is the foundation of state budgetary process, ensuring legislative control over state finances. And yes, the distinction between charged and votable expenditure is key for ensuring the independence and uninterrupted functioning of certain constitutional offices, like the High Court judiciary. For example, when the state finance minister presents the budget, the section concerning High Court judges' salaries can be discussed, but it is not put to a vote, safeguarding judicial independence from legislative financial pressures.
Following on from that, Article 203 details the procedure in legislature with respect to estimates, or how the Assembly actually votes on these grants.
This article precisely bifurcates the legislative procedure for expenditure estimates. Clause 1 clarifies that charged expenditure, as we just discussed, is not submitted to the Assembly's vote, though it can be discussed. However, Clause 2 specifies that the other expenditure, the votable portion, is submitted as demands for grants to the Legislative Assembly. The Assembly then has the power to assent, refuse, or reduce these demands through what are known as cut motions. The Legislative Council, notably, does not vote on these grants. Clause 3 adds a crucial point. No demand for a grant can be made except on the governor's recommendation. This ensures executive initiative in financial matters, meaning the government proposes the spending. This article clearly establishes the primacy of legislative assembly in financial control, and the refusal of a grant or a significant cut can often signal a loss of confidence in the government. For instance, a demand for a grant for the State Department of Education is debated and voted on by the Legislative Assembly, and an MLA can move a cut motion to reduce funds for a particular scheme within that demand if they believe it's wasteful or inefficient.
And once those grants are approved, Article 204 comes into play with appropriation bills, which effectively legalize state spending. This gives the legal okay to spend the money.
Precisely. This article mandates that all withdrawals from the consolidated fund of a state must be authorized by a State Appropriation Act, thereby providing legal sanction to approved expenditures. It mirrors Article 114 for the Union. Clause 1 requires that as soon as grants are voted by the Assembly, a bill is introduced to authorize the withdrawal of money from the state consolidated fund to cover both the voted grants and the charged expenditure. Clause 2 then places strict restrictions on amendments to this appropriation bill. No amendment can be proposed that would vary the amount or alter the destination of a grant or charged expenditure that has already been approved. The presiding officer's decision on the admissibility of such amendments is final. Crucially, Clause 3 states a fundamental principle. No money can be withdrawn from the state consolidated fund except under an appropriation made by law. This is a fundamental constitutional mandate for lawful state expenditure. The appropriation bill itself is treated as a money bill, reinforcing the Assembly's financial supremacy. For example, after all demands for grants are passed and approved, an appropriation bill is introduced.
Once it becomes law, the government is legally authorized to spend those specific amounts for those specific purposes. An MLA cannot, at this stage, propose an amendment to divert funds from, say, a road project to a hospital project, as that would alter the destination of an already approved grant.
So that covers the initial budget, but what if the state needs more money later in the year, perhaps due to unforeseen events, or maybe has even spent too much? Article 205 covers supplementary, additional, or excess grants.
This article provides essential flexibility in state financial management for unforeseen needs. It allows the state government to seek further legislative approval for expenditure beyond the initial budget in specific circumstances, mirroring Article 115 for the Union. Clause 1 specifies these circumstances. A supplementary grant is sought if the initial funds for an existing service are found to be insufficient. An additional grant is needed if new expenditure arises that was not included in the annual budget. Or an excess grant is sought if money has already been spent in excess of the amount granted for a particular service. The procedure under Clause 2 for approving these is the same as for the annual budget, meaning they go through the demands for grants and appropriation bill process, Articles 202-204. This maintained continuous legislative oversight of state finances, even for mid-year adjustments. An example would be an unexpected flood or severe drought leading to an urgent need for more disaster relief funds than initially budgeted. The state government would then present supplementary demands to the Assembly for approval.
And for even more urgent or extraordinary situations, like maybe during an election year, Article 206 allows for votes on account, votes of credit, and exceptional grants, providing for critical contingency spending.
Yes, these are crucial tools for flexibility in state financial management to ensure essential government functions continue even when the regular budget process is delayed or for truly extraordinary needs. They mirror Article 116 for Parliament. Clause 1 outlines 3 types. A vote on account, subclause A, is an advance grant for a part of the financial year, usually for a few months, pending the full budget passage. This is very common during election years, as you mentioned. A vote of credit, subclause B, is for unexpected, large, or indefinite demands that cannot be precisely estimated in the ordinary annual financial statement. Think maybe massive unforeseen disaster relief. And an exceptional grant, subclause C, is for a special purpose that doesn't form part of the current year's ordinary service. In all these cases, the state legislature authorizes the withdrawal of funds by law. The procedure, as per Clause 2, is the same as for regular demands and appropriation bills, Articles 203 and 204. So, if state assembly elections are imminent and the new government won't be in place to pass a full budget before the new financial year begins, the outgoing government might pass a vote on account to cover essential expenses for the first few months,
ensuring continuity of governance.
Finally, for financial matters, we have Article 207, Special Provisions as to Financial Bills. This deals with bills that have financial implications but aren't strictly money bills requiring the governor's recommendation. How do these differ?
This article deals with financial bills at the state level, which are distinct from money bills, but nonetheless have significant financial implications. They require special procedures, primarily the governor's recommendation, mirroring Article 117 for Parliament. We essentially have two categories here. Financial bills Category 1, under Clause 1, are those bills that contain matters from Article 189A, meaning they touch upon some aspects of money bill matters like taxation or borrowing, plus other general legislative matters. Because they have this mixed character, they must be introduced only in the Legislative Assembly and require the governor's recommendation for their introduction. An important exception is if an amendment proposes to reduce or abolish any tax for which no prior recommendation is needed. Otherwise, once introduced, they are treated like ordinary bills, meaning the council can amend or reject them, and any deadlock would be resolved by the procedure in Article 197.
Okay, that's Category 1. And what about financial bills Category 2?
Financial bills Category 2, under Clause 3, are those bills that do not contain any of the specific money bill matters, but do involve expenditure from the State Consolidated Fund. These bills are less restrictive in their introduction. They can be introduced in either house. However, they cannot be passed by a house unless the governor has recommended its consideration. Clause 2 further clarifies what is not a financial bill. For example, bills merely imposing fines, pecuniary penalties, fees for licenses services, or local taxes by local authorities. This article ensures executive initiative in state financial legislation. The governor's recommendation here signifies the state government's approval, ensuring financial prudence for bills with significant financial implications, even if they aren't purely money bills. For instance, a bill to establish a new state university, which is general legislation, that also includes a clause for levying a special cess to fund it, would be a financial bill category first. It must be introduced in the Assembly with the governor's recommendation.
Beyond financial matters, how do state legislatures ensure their own smooth functioning, and what are the crucial restrictions that define their operational boundaries, particularly concerning the judiciary?
This brings us to Article 208, which deals with rules of procedure and signifies the autonomy in functioning for the state legislatures, mirroring Article 118 for Parliament. The core concept here is empowering each house of a state legislature to make its own rules for regulating its procedure and the conduct of its business. Clause 1 gives each house this power, but importantly, it's subject to the provisions of this Constitution. They can't make rules that violate the Constitution. Clause 2 acts as an interim provision, stating that until new rules are made, the rules of procedure and standing orders in force before the Constitution's commencement would apply. Today, of course, state legislatures have their own established rules. In bicameral states, Clause 3 allows the governor, after consulting the Speaker of the Assembly and the Chairman of the Council, to make rules for communications between the two houses. This article essentially establishes the autonomy of houses in managing their internal affairs, which is crucial for independent legislative functioning. For example, a state legislative assembly might vote to amend its rules of procedure to streamline debate time for certain types of bills to enhance efficiency.
That flexibility for internal management is certainly important. Then Article 209 addresses regulation by law of procedure in the legislature of the state in relation to financial business, specifically focusing on timely budget passage. Why a separate article for this?
Good point. The core concept here is that a state legislature can make a law not just internal rules to regulate its financial business procedures, and crucially, such a law will prevail over the House's general rules of procedure if inconsistent. This mirrors Article 119 for Parliament. The primary purpose of such a law is to ensure the timely completion of financial business. This law can cover any financial matter or appropriation bills. This statutory override then prevails over any inconsistent House rules made under Article 208. This provision ensures the necessity of timely financial sanction at the state level. It's a specific power designed to ensure the state budget and other critical financial legislation are passed within the required timelines, preventing procedural delays from crippling the state's finances. So, for example, to ensure its budget is passed before the new financial year, a state legislature might enact a law under Article 209, setting strict, shorter time limits for debates on demands for grants, which would then override its usual, more flexible procedural rules.
And what about the language to be used in the legislature, covered by Article 210? That must be crucial in a multilingual country like India. How does it work?
Absolutely.
Article 210 specifies the languages for transacting business in state legislatures. Business can be conducted in the official languages of the state, or Hindi or English. However, there's a crucial proviso to Clause 1. The Speaker or Chairman may permit a member who is unable to express adequately in the listed languages to speak in their mother tongue. This is a very progressive measure to ensure inclusivity. Originally, Clause 2 envisaged phasing out English after 15 years from the commencement of the Constitution, unless the state legislature provided otherwise by law. It's important to note that most state legislatures have enacted laws to continue the use of English. This article ensures linguistic pluralism at state level and reflects the autonomy of state legislatures in their internal language use. For instance, in the Karnataka Legislative Assembly, while business is primarily conducted in Canada and English, an MLA who prefers to speak in Konkani can seek permission from the Speaker, ensuring their voice is heard.
Now here's a critical restriction. Article 211, restriction on discussion in the legislature, which is designed to protect judicial independence. What can't they discuss?
This is a fundamental safeguard for the independence of the judiciary. Article 211 explicitly prohibits state legislatures from discussing the conduct of any judge of the Supreme Court or a high court in the discharge of their duties. The prohibition is stark. No discussion shall take place in the legislature of a state on the conduct of any judge of the Supreme Court or of a high court, specifically in the discharge of his duties, meaning their judicial functions or decisions. This provision reinforces the separation of powers, preventing state legislatures from becoming forums for criticizing judicial conduct, which could undermine public confidence or put undue pressure on judges. It differs from Article 121, which applies to Parliament and allows for such discussion only during a formal removal motion, as state legislatures do not possess the power to remove higher court judges. So if a high court passes a judgment that is unpopular with the state government, members of the state legislature cannot initiate a discussion within the House criticizing the conduct of the judges who delivered that judgment.
They can certainly discuss the impact of the judgment or the need for new legislation in response, but not question the judge's actions in performing their duties. The Keshav Singh versus Speaker Legislative Assembly case highlighted the importance of mutual respect and non-interference between these branches of government.
And complementing that, Article 212, courts not to inquire into proceedings of legislature, ensures legislative autonomy from judicial scrutiny on specific grounds. So courts can't interfere with internal legislative business.
Mostly, yes, but with caveats. This article provides immunity to state legislature proceedings from judicial questioning on grounds of procedural irregularity. It also protects legislative officers and members in regulating procedure or maintaining order. It mirrors Article 122 for Parliament. Clause 1 states that the validity proceedings shall not be called in question on the ground of any alleged irregularity of procedure. Clause 2 further grants immunity to presiding officers or any member who exercises powers for regulating procedure or maintaining order, ensuring they are not subject to court jurisdiction for exercising those powers. This establishes the exclusive cognizance of internal legislative proceedings and reinforces parliamentary legislative privilege. It ensures the legislature can function without constant judicial interference on minor procedural matters.
So it's about respecting the internal functioning of the legislature. But this immunity isn't absolute, is it? What if they violate the Constitution itself, not just a rule?
That's a very important distinction. This immunity is only for procedural irregularity. It does not shield the legislature from judicial scrutiny if it violates a mandatory constitutional provision, which would be a substantive unconstitutionality, or acts without proper jurisdiction or commits gross illegality. The Keshav Singh case, again, affirmed internal autonomy, but indicated that courts could intervene if fundamental rights were violated or if the legislature acted beyond its constitutional jurisdiction. More recently, the state of Kerala versus K. Ajith case implicitly suggested that gross illegalities, like vandalism within the House, are not shielded from legal processes if such acts are not considered part of essential legislative functions. So if a bill is passed and a member alleges the notice period for an amendment was shorter than House rules stipulated, the validity of the act generally cannot be challenged in court on this procedural ground. However, if the legislature passed a law on a subject that falls exclusively under the Union list, meaning it had no legislative competence to do so, then that law could certainly be challenged in court.
Okay, that clarifies the limits. Now, while the legislature is paramount, there is an extraordinary power vested in the governor to legislate when the assembly is not in session, the power to promulgate ordinances.
Yes, this brings us to Article 213, power of governor to promulgate ordinances during recess of legislature, which is a form of executive legislation intended for emergency situations. Its core concept grants the governor the power to issue ordinances when the state legislature is not in session and urgent action is needed. These ordinances carry temporary legislative force but are always subject to eventual legislative approval, mirroring Article 123 for the president.
So what are the specific conditions under which the governor can promulgate such an ordinance, and are there any critical restrictions perhaps involving the president?
Clause 1 lays out the conditions. The legislative assembly, or both houses in a bicameral state, must not be in session, and the governor must be satisfied that circumstances exist that require immediate action. This satisfaction is not the governor's personal whim, but rather that of the state executive, meaning the Council of Ministers. However, there are crucial restrictions outlined in the proviso to Clause 1. The governor cannot promulgate certain ordinances without the president's prior instructions. This applies if a similar bill would require the president's prior sanction for its introduction, or if the governor would have deemed it necessary to reserve a similar bill for the president's consideration, or if a similar state act would be invalid without the president's assent, for example, due to repugnancy with the union law under Article 2542. These restrictions ensure a measure of union supervision in specific, sensitive legislative areas.
So how long do these ordinances last, and do they have the same weight as a proper law passed by the legislature?
Clause 2 clarifies that an ordinance has the same force and effect as a state act. However, it is inherently temporary. It must be laid before the legislature when it reassembles and ceases to operate at the expiration of 6 weeks from reassembly, or earlier if a resolution disapproving it is passed by the assembly. The governor also retains the power to withdraw it at any time. Clause 3 is equally critical. An ordinance is void if it makes provisions that the state legislature is not competent to enact, for example, legislating on subjects exclusively in the Union list. Interestingly, the proviso to Clause 3 states that an ordinance promulgated with President's instructions on a concurrent list matter is treated like a state act that has been reserved for and assented to by the President, allowing it to potentially prevail over a Union law under Article 234(2).
This sounds like a powerful but conditional legislative power for the executive, intended strictly for emergent situations. Has its use been controversial?
Absolutely. It's a conditional legislative power of the executive, clearly intended for emergent situations. While Clause 4 of this article, which made the governor's satisfaction non-justiciable, was omitted by the 44th Amendment, the Supreme Court has since held that this satisfaction is indeed subject to limited judicial review, for instance, if it's based on bad faith, malefides, wholly extraneous grounds, or constitutes a fraud on the Constitution. What's particularly fascinating, and has been a source of significant constitutional debate and controversy, is the practice of repeatedly repromulgating ordinances without ever placing them before the legislature for proper debate and passage. The Supreme Court has strongly condemned this practice as unconstitutional in landmark cases like D.C. Wadhwa versus State of Bihar and, more recently, Krishna Kumar Singh versus State of Bihar. They termed it a fraud on the Constitution and a subversion of the democratic legislative process. This article really highlights the supremacy of the legislature and the delicate balance required in separation of powers, with only qualified exceptions for executive legislation.
From the lawmaking bodies, we now turn to the critical institutions responsible for administering justice and upholding the Constitution at the state level, the high courts. A fundamental shift.
Indeed. We begin with Article 214, High Courts for States. Its core concept is straightforward, yet absolutely fundamental. It mandates the establishment of a high court for each state. The basic ingredient is simply, there shall be a high court for each state.
So it's a mandatory foundational provision establishing the high court at the apex of the state judiciary. Though I understand Article 231 allows for common high courts for 2 or more states, which is an interesting exception we can touch on later.
That's right, and that flexibility under Article 231 is an important detail that highlights the adaptability of our constitutional framework. Then we have Article 215, High Courts to be courts of record. This article declares every high court to be a court of record and explicitly grants it the inherent power to punish for its own contempt.
What exactly does being a court of record entail, and why is that power to punish for contempt so significant for a high court? Does it protect their authority?
Precisely. Being a court of record means 2 crucial things. First, their proceedings and judgments are permanently recorded and possess evidentiary value, meaning their accuracy cannot be questioned in any subordinate court. Second, and equally important, This status intrinsically grants them the power to punish for their own contempt. This provision is vital. It upholds the dignity, authority, and majesty of the high courts. The power to punish for contempt is constitutionally recognized as an inherent power, not merely a statutory one. It's a wide power, covering both civil and criminal contempt, and importantly, it extends not just to contempt of the high court itself, but also to contempt of subordinate courts. This ensures the high court can protect the entire administration of justice within its jurisdiction. While a powerful tool, it's expected to be exercised with caution and restraint. The Sukhdev Singh Sodhi versus Chief Justice S. Tejas Singh case affirmed this as a constitutional power, and Delhi Judicial Service Association versus State of Gujarat confirmed its extension to contempt of subordinate courts.
So if a party willfully disobeys a high court order, the high court can initiate contempt proceedings and punish them. Similarly, if someone makes scurrilous allegations against a district judge, the high court can take suo motu cognizance of contempt of a subordinate court.
Got it. Then Article 216 covers the constitution of high courts, defining their basic composition. How is that decided?
This article is very concise and provides the basic blueprint. Every high court shall consist of a chief justice and such other judges as the president may from time to time deem it necessary to appoint. The key takeaway is that the number of other judges is not fixed by the Constitution, allowing for flexibility and strength based on the workload, pendency, and recommendations made by the judiciary. The Chief Justice, beyond their judicial role, is also the administrative head of the High Court. For instance, based on an increasing caseload and a growing backlog of cases, the President, after due process and consultation, might increase the sanction strength of a particular High Court.
And then Article 217, which is a big one. Appointment and conditions of the office of a judge of a high court. This is all about ensuring a truly independent judiciary, the appointment process, tenure, and so on.
Absolutely.
Yeah.
Article 217 is the primary provision governing the appointment, qualifications, tenure, resignation removal, and age determination for high court judges, all meticulously designed to foster a competent and fiercely independent judiciary. Appointments are made by the President by warrant under hand and seal. The consultation process is mandatory and crucial. It involves consultation with the Chief Justice of India, CJI, the Governor of the state, and for judges other than the Chief Justice, also the Chief Justice of the High Court.
I understand this consultation process has evolved significantly over time, and the interpretation has been quite a journey through landmark cases leading to the collegium system.
It's a truly fascinating and foundational evolution in Indian constitutional law. This consultation process, interpreted through a series of judges' cases, starting from S.P. Gupta, then the crucial second judge's case, and the third judge's case, has significantly shifted, ultimately establishing the collegium system. In this system, the judiciary's recommendation, formed through the CJI and senior-most Supreme Court judges, has primacy for appointments. This evolution is absolutely crucial for safeguarding the independence of high court judiciary from executive interference. Judges hold office until the age of 62. Their office can be vacated through resignation to the President, removal by the President, which follows the same rigorous impeachment-like process as the Supreme Court judge under Article 124, appointment to the Supreme Court, or transfer to another high court. Qualifications require being a citizen of India and either having held a judicial office for at least 10 years or having been an advocate of a high court or successive high courts for at least 10 years. If any question arises as to a judge's age, Clause 3 states it's decided by the President after consultation with the CJI, and that decision is final.
So this article is central to the independence of judiciary, state level, and ensures security of tenure and conditions of service. And the Sekhawar versus Union of India, often called the NJC case or Fourth Judge's case, is a landmark here, reaffirming the collegium system as part of the basic structure of the Constitution. That's vital context.
Precisely. That case was pivotal in reinforcing the judicial independence enshrined by this article. Following this, Article 218 is straightforward but vital. It ensures the application of certain provisions relating to Supreme Court to high courts, specifically regarding the removal procedure. Its core concept extends the rigorous impeachment-like procedure for the removal of Supreme Court judges, Article 124 and 5, directly to high court judges. This means the same grounds, proved misbehavior or incapacity, and the same parliamentary procedure requiring an address by both houses with special majorities and a presidential order apply. This ensures the security of tenure for judiciary for high court judges, protecting them from arbitrary removal and thereby significantly strengthening judicial independence at state level. For example, if serious allegations of proved misbehavior arise against a high court judge, the procedure for their removal would be exactly the same as for a Supreme Court judge, initiated in Parliament, thoroughly investigated, and then voted upon by both houses. Very difficult, as it should be.
Agreed. Then, Article 219 covers the oath or affirmation by judges of high courts, a solemn commitment they make.
Yes, this article mandates a solemn oath or affirmation by every high court judge before entering office, binding them to the Constitution and their judicial duties. The oath is taken before he enters upon his office, administered by the governor of the state or an appointee, and follows the specific form set out in the third schedule of the Constitution. This includes pledges to uphold the Constitution, the sovereignty and integrity of India, and to perform duties without fear or favor, affection or ill will. This is a constitutional mandate reinforcing judicial independence and impartiality, a public declaration of allegiance to the fundamental law of the land, and a commitment to impartial justice.
And finally, for this section, Article 220 imposes a restriction on practice after being a permanent judge. This is about maintaining dignity and preventing conflicts of interest, isn't it? So they can't just practice anywhere.
That's absolutely right. The core concept here is to restrict a former permanent high court judge from practicing law in certain courts or before certain authorities in India, primarily to maintain judicial dignity and avoid any perception of conflict of interest or undue influence. It applies to any permanent judge of a high court after the Constitution's commencement. The restriction prohibits them from pleading or acting in any court or before any authority in India. The key exceptions are that they can plead or act in the Supreme Court and other high courts. They just can't practice in the high court they retired from or courts subordinate to it. This provision aims at maintaining judicial dignity and propriety and preventing conflict of interest or undue influence. Conventionally, judges very consciously avoid practicing in the same high court where they served. So, for example, a retired permanent judge of the Mumbai High Court could practice as an advocate in the Supreme Court or in the Delhi High Court, but typically not in the Mumbai High Court or any court subordinate to it, thus ensuring a clear separation from their previous judicial role.
Okay, that makes sense. Now, beyond their core structure and appointments, how are high court judges compensated, moved between courts, and how does the system ensure that the courts can respond to fluctuating workloads and temporary shortages?
These are all critical questions that directly impact judicial independence, and Article 221 addresses salaries, etc. of judges, ensuring their financial independence, mirroring Article 125 for Supreme Court judges. The core concept is to ensure financial security and independence of high court judges by having their salaries and emoluments determined by Parliament, coupled with a crucial safeguard against disadvantageous changes after their appointment.
So Parliament determines their salaries, allowances, leave, and pension. But there's a really important protective proviso in Clause 2, isn't there? Safeguarding their financial well-being. They can't have their terms worsened after joining.
Yes. The proviso to Clause 2 is a cornerstone for independence of the judiciary. It states crucially that neither allowances nor rights in respect of leave or pension shall be varied to his disadvantage after his appointment. This means judges can perform their duties without fear or favor by securing their financial well-being, knowing their service conditions won't be arbitrarily worsened after they take office. Their salaries are charged on the state consolidated fund, making them non-votable, and their pensions are charged on the Consolidated Fund of India, further enhancing their financial independence from any specific state government. For example, if Parliament passes a law increasing high court judges' salaries, that's perfectly acceptable. However, an already appointed judge's pension entitlements cannot be reduced by a subsequent law if it disadvantages them compared to what was applicable at the time of their appointment. Next, Article 222 covers the transfer of a judge from one high court to another. This sounds like a mechanism that tries to balance the administrative needs of the judicial system with the independence of individual judges. Is that fair?
It certainly tries to be. The core concept empowers the president to transfer a high court judge, but only after a mandatory consultation with the Chief Justice of India. Clause 1 clearly states this. Clause 2 also provides for a compensatory allowance for the transferred judge, determined by Parliament or the President. The interpretation of consultation in this context has undergone a significant evolution through the judges' cases, which established the primacy of the CJI's recommendation formed through the Collegium for Transfers. This acts as a vital safeguard against arbitrary transfer and is crucial for ensuring independence of judiciary.
This power is typically used to balance judicial talent across high courts, provide wider judicial experience, or address specific administrative needs, but it cannot be used as a punitive measure. Landmark cases like Union of India versus Sankal Chand Himat Sheth and the Supreme Court Advocates on Record Association versus Union of India, second judge's case, clarified these principles, especially the CGI's primacy. For instance, the Supreme Court Collegium might recommend the transfer of a judge from one high court to another to help manage a backlog of cases or address a specific administrative situation, and the president then issues the order based on that recommendation.
And for continuity of leadership in the high courts, Article 223 allows for the appointment of acting Chief Justice. What if the Chief Justice is unavailable?
This article ensures continuity of the Chief Justice's office by empowering the President to appoint another judge to act as Chief Justice when the office is vacant or the Chief Justice is unable to perform their duties, mirroring Article 126 for the Supreme Court. The circumstances are clear. Either the office of the Chief Justice is vacant or the Chief Justice is unable to perform their duties due to absence, illness, or some other reason. The President then appoints such one of the other judges of the court to perform those duties. This is a temporary arrangement designed to ensure continuity of judicial office. By convention, the senior most available judge of that high court is usually appointed. An acting Chief Justice performs all the administrative and judicial functions of the Chief Justice during that temporary period. So, if the Chief Justice of a high court takes an extended period of leave, the President appoints the next senior-most judge at that high court to perform the duties of the Chief Justice during that temporary period.
Okay. And to manage fluctuating workloads and temporary shortages, Article 224 covers the appointment of additional and acting judges. These are temporary appointments.
Yes, this article provides essential flexibility in judicial staffing. It allows for the temporary appointment of additional judges to handle increased workload or clear judicial arrears, and acting judges to fill temporary vacancies of permanent judges. Clause 1 allows the President to appoint qualified persons as additional judges for a period not exceeding 2 years, specifically when there's a temporary increase in business in the High Court or a significant backlog of work. Clause 2 covers acting judges. When a permanent judge, other than the Chief Justice, is unable to perform their duties due to absence or for any other reason, or is temporarily acting as Chief Justice, the President can appoint a duly qualified person to act as a judge until the permanent judge resumes their duties. Crucially, as per Clause 3, neither additional nor acting judges can hold office after reaching the age of 62, which is the retirement age for high court judges. These are temporary judicial service appointments, providing a practical mechanism to address backlogs and temporary shortages without having to make permanent appointments. For example, if a high court has a massive backlog of cases, the President might appoint several qualified advocates as additional judges for up to 2 years to help clear those arrears. If a permanent judge goes on long leave, a qualified person is appointed as an acting judge until that permanent judge returns.
And finally, to leverage that deep experience of retired judges, Article 224A allows for the appointment of retired judges at sittings of high courts. How does this work?
This article enables the Chief Justice of a high court, with the President's consent, to request a retired high court judge to temporarily sit and act as a judge. The core concept is to clear judicial arrears and continue to utilize the valuable contribution of experienced judges, mirroring Article 128 for the Supreme Court. The initiative comes from the Chief Justice of the High Court, but importantly, it requires the previous consent of the President before such a request can be made. Eligible persons include anyone who has previously held office as a judge of that court or any other high court. While sitting and acting, such a retired judge enjoys all the jurisdiction, powers, and privileges of a regular judge. However, they shall not otherwise be deemed to be a judge of that high court, meaning their temporary role doesn't confer permanent judicial status. Crucially, there's a proviso. The consent of the retired judge is absolutely necessary. They are not obliged to accept the request. This is a crucial tool for clearing judicial arrears and continuing contribution of experienced judges. It's not a regular mode of appointment, but a specific temporary measure to utilize judicial expertise effectively. The Supreme Court, in cases like Lok Prahari versus Union of India in 2021, has recently urged a more robust and streamlined use of this provision to tackle the persistent problem of pendency in high courts. For instance, if a high court struggles with an accumulation of old civil appeals, the Chief Justice, with presidential consent, might request a retired judge specializing in civil law to sit and hear these specific appeals for a year, bringing their expertise to bear on the backlog.
Now we come to the real meat of the High Court's role. Its vast and extensive jurisdiction, particularly its power to issue writs and superintend other courts, making it a powerful guardian of justice at the state level. This is where their power really shows.
Absolutely. This begins with Article 225, Jurisdiction of Existing High Courts, which is essentially a transitional provision ensuring continuity and evolution. Its core concept ensures the continuity of the jurisdiction, powers, and administrative procedures of high courts that were existing at the commencement of the Constitution, but always subject to the Constitution itself and any new laws enacted.
So it essentially meant that the high courts largely retained their powers from the pre-Constitution era unless explicitly changed by new laws, like their inherent powers.
Exactly. The existing jurisdiction, the law administered by the high courts, and the judges' administrative powers continued just as they were before the Constitution came into force. However, this continuity is explicitly stated to be subject to the provisions of this Constitution and to the provisions of any law of the appropriate legislature, meaning either Parliament or state legislatures. This implies that these powers could be, and have been, modified within their respective legislative competences. What's particularly crucial here is the proviso, which was significantly shaped by the 44th Amendment. This proviso removed any pre-Constitution restriction on the High Court's original jurisdiction in revenue matters or acts done in the collection of revenue. This is highly significant because it expanded the High Court's judicial review powers over revenue-related executive actions, reversing an earlier curtailment that had occurred through the 42nd Amendment during the emergency. So, for example, if a High Court's letters patent jurisdiction, a special type of original jurisdiction derived from its colonial past, continued under Article 225, now any historical bar on challenging revenue collection acts in that High Court is explicitly removed, giving citizens greater recourse.
And now, the truly expansive power, Article 226, power of high courts to issue certain writs. This is often called the People's Protector, for good reason. It's incredibly powerful.
It absolutely is, and it stands as a cornerstone of judicial review in India. Article 226 confers extraordinarily wide powers on high courts to issue directions, orders, and various prerogative writs, such as habeas corpus, mandamus, prohibition, quo warranto, and certiorari. These can be issued for two critical purposes. First, for the enforcement of fundamental rights, those rights guaranteed in Part 3 of the Constitution, and second, for any other purpose, meaning for the enforcement of any other legal right. Clause 1 states these powers are exercised notwithstanding anything in Article 32, indicating they are independent of the Supreme Court's writ power. High courts can issue these writs throughout their territorial jurisdiction to any person or authority, including the government itself.
What's genuinely fascinating here is that, for any other purpose phrase, it makes the High Court's writ jurisdiction significantly wider than the Supreme Court's under Article 32, which is primarily restricted to fundamental rights. This truly positions the High Court as a primary instrument for judicial review at the state level. And I recall Clause 2 also deals with territorial jurisdiction based on where the cause of action arises. That was an important change.
Precisely. Clause 2 allows a high court to issue writs, even if the respondent, the government official or entity against whom the writ is sought, is outside its physical territory, provided the, quote, cause of action, wholly or in part, arises within its territories. This is a crucial and practical addition by the 15th Amendment, specifically introduced to overcome earlier restrictive interpretations of territoriality. Clause 3 then adds a significant procedural safeguard inserted by the 44th Amendment. If an ex parte interim order, meaning a temporary order made without hearing the other side, is issued by the High Court, the aggrieved party can apply for its vacation. In such a scenario, the High Court must dispose of that application within 2 weeks, or the order stands vacated automatically. This prevents indefinite ex parte orders. Clause 4 clarifies that this power does not diminish the Supreme Court's Article 32 power. This article is undeniably a cornerstone of judicial review in India and a powerful tool for being a guardian of fundamental and legal rights. It's an extraordinary discretionary remedy, and importantly, it forms the very basis for public interest litigation, PIL, in India.
So, for instance, if a citizen's freedom of speech is arbitrarily restricted by a state authority, they can directly approach the High Court under Article 226. Or, if a public servant is illegally dismissed from service, they too can approach the High Court for reinstatement. The L. Chandra Kumar versus Union of India case even declared Article 226 power as part of the Constitution's basic structure. That shows its fundamental nature.
Absolutely, it's that fundamental. Next, we have Article 227, power of superintendence over all courts by the High Court. This is about ensuring administrative and judicial oversight across the entire judicial hierarchy in the state. Its core concept confers on every high court the expansive power of superintendence over all courts and tribunals throughout its territorial jurisdiction. This power is both administrative and judicial.
So it's a very broad supervisory role. What exactly does that superintendence involve in practice? Can they tell lower courts what to do?
It's more subtle than simply telling them what to do in specific cases, but it's very powerful. Clause 1 grants this very broad power over all courts and tribunals within its territory, with one exception we'll get to. Clause 2 then details its administrative aspects, including calling for returns from such courts, making general rules and prescribing forms for their practice and proceedings, and prescribing forms for keeping records. Clause 3 allows the High Court to settle fees for court officers and legal practitioners, though such rules require the governor's approval. Clause 4 is that important exception. This power does not extend to courts or tribunals relating to the armed forces. This is a very broad power, ensuring judicial hierarchy and discipline. It's often considered wider than Article 226 in some respects. It can be used to correct errors of jurisdiction, errors of law apparent on record, or to ensure duties are performed by lower courts. But it's crucial to remember it's not a substitute for an appeal. The 44th Amendment restored its wider judicial scope after the 42nd Amendment had curtailed it.
Variam Singh versus Amarnath clearly held this power is both administrative and judicial, and Surya Dev Rai versus Ramchandra Rai discussed its precise scope, distinguishing it from Article 226. For example, if a subordinate civil court passes an order that is patently without jurisdiction, causing grave injustice, the High Court can intervene under Article 227. Or, on the administrative side, the High Court might issue general rules to all district courts on improving timely case disposal.
Finally, for this section, Article 228 deals with the transfer of certain cases to High Court, ensuring authoritative constitutional interpretation for complex legal questions. When does this happen?
This article empowers a High Court to withdraw a case from a subordinate court if it involves a substantial commitment of law as to the interpretation of the Constitution, and the High Court is satisfied that the determination of this question is necessary for the case's disposal. If the High Court is satisfied that these conditions are met, it shall withdraw the case. After withdrawal, the High Court has two clear options. It can either dispose of the entire case itself, or it can determine only the specific question of constitutional law, and then return the case to the subordinate court with its judgment on that question, which is then binding on the lower court. This mechanism ensures authoritative interpretation of constitutional provisions by the High Court, preventing conflicting interpretations in lower courts, and firmly establishing its role as guardian of the Constitution at state level. The Raja Ganga Pratap Singh versus Allahabad Bank Ltd case emphasized the need for strict satisfaction of these conditions before exercising such a withdrawal power. For instance, in a criminal trial, if the accused challenges the constitutional validity of a particular penal provision, and that validity is central to the outcome, the High Court can withdraw the case, decide the constitutional question, and then send the case back to the Sessions Court to proceed based on its authoritative ruling.
Okay, that makes sense for complex constitutional issues. Finally, let's complete our picture of high courts by understanding their internal administration, their reach across union territories, and the ingenious system of common high courts for multiple states.
Right. This brings us to Article 229, Officers and Servants and the Expenses of High Courts, which is crucial for safeguarding their administrative autonomy. The core concept here ensures the administrative independence of high courts by vesting primary control over their staff, both their appointments and service conditions, in the Chief Justice. It also secures their financial independence by charging their administrative expenses on the state's consolidated fund.
So the Chief Justice largely controls staff appointments. But there are some checks on that power, particularly regarding financial rules, right? The governor has a say.
Yes. Clause 1 states that appointments of officers and servants of the High Court are made by the Chief Justice or by an officer or other person directed by the Chief Justice. However, there's a proviso that allows the governor to require, by rule, consultation with the State Public Service Commission for certain types of non-attached appointments. Clause 2 states that the conditions of service for these staff members are prescribed by the Chief Justice's rules, subject to any law made by the State Legislature. And another crucial proviso to Clause 2 requires the governor's approval for any rules that relate to the salaries, allowances, leave, or pensions of the staff. Finally, Clause 3 states that the administrative expenses of a high court, including the salaries, allowances, and pensions of its officers and servants, are charged upon the consolidated fund of the state and are therefore non-votable. This is vital for the independence of the judiciary, administrative and financial. While the Chief Justice has primal administrative matters, the governor's approval for financial rules acts as a necessary check, but not an arbitrary veto, ensuring prudence.
Landmark cases like M. Gurumurthy versus Accountant General and High Court of Judicature for Rajasthan versus Rameshchan Paliwal have consistently emphasized the Chief Justice's exclusive power and the importance of this autonomy for judicial independence.
And how do high courts extend their reach beyond a single state? Article 230 covers the extension of jurisdiction of high courts to union territories, reflecting parliamentary authority.
This article explicitly empowers Parliament to extend or exclude an existing high court's jurisdiction to or from any union territory, clarifying legislative powers and procedural adaptations. Clause 1 states that Parliament may do this by law. Clause 2a clarifies that if a state high court exercises jurisdiction over union territory, the state legislature cannot alter that jurisdiction. That power rests solely with Parliament. Clause 2b also adapts references. For a state high court exercising jurisdiction over a UT, any reference to the governor in Article 27, which relates to superintendent's rules for subordinate courts, becomes a reference to the president. This reflects parliamentary authority over union territories and ensuring judicial administration for UTs within a unified national judicial system. For example, Parliament has passed laws extending the jurisdiction of the Kerala High Court to Lakshadweep, which is a union territory. In such a scenario, the Kerala State Legislature cannot then pass a law restricting this jurisdiction for Lakshadweep. Any rules made by the Kerala High Court for subordinate courts in Lakshadweep would need the president's approval, not the governor's.
And finally, a truly clever and pragmatic arrangement. Article 231, establishment of a common high court for 2 or more states, a matter of judicial economy and resource sharing.
Exactly. This article empowers Parliament to establish a common high court for 2 or more states, or for states in a union territory, providing for judicial economy and administrative convenience. Clause 1 explicitly allows Parliament to do this notwithstanding anything in Article 214, which, as we discussed, mandates a high court for each state. So this is a direct exception. Clause 2 then provides crucial adaptations for how various constitutional provisions apply to such a common high court. For instance, in appointing judges to a common high court, the governor of the state referenced in Article 217 is construed as a reference to the governors of all the states in relation to which that common high court exercises jurisdiction. Similarly, references to the state for the oath of judges, Article 219, and administrative expenses, Article 229, are construed as referring to the state in which the common high court has its principal seat. If that principal seat happens to be in a union territory, the references shift to the President, UPSC, Parliament, and Consolidated Fund of India, respectively, aligning with union control over UTs.
So this is an important exception to the high court for each state principle, truly reflecting cooperative federalism and judicial integration. It makes practical sense.
Exactly. It allows for sharing resources, optimizing judicial talent, and ensuring effective judicial administration for smaller or contiguous regions. The Guwahati High Court, for instance, famously serves Assam, Nagaland, Mizoram, and Arunachal Pradesh. When a judge is appointed to this common high court, the president consults the governors of all these states, ensuring all stakeholders are involved in the process. It's a pragmatic and efficient approach to judicial infrastructure in our diverse federal setup.
And there you have it, a comprehensive deep dive into the intricate constitutional tapestry that governs our state legislatures and high courts. From the nuances of who gets to represent you to the immense power of a governor's assent and the high court's absolutely vital role as guardians of your rights and the Constitution, we've truly covered a lot of ground today. Phew.
What stands out, I hope, is the deliberate and sophisticated design behind these articles. They meticulously strive to balance legislative efficiency with accountability and judicial independence with necessary checks and balances. The continuous evolution of their interpretation through constitutional amendments and landmark judgments truly brings these static texts to life, vividly showing how our Constitution remains a living, breathing document, constantly responding to contemporary challenges and unforeseen situations.
Absolutely. The next time you hear about a state budget being presented, a new state law being debated, or a high court delivering a significant ruling, you'll now have a much richer, deeper understanding of the constitutional gears turning powerfully behind the scenes. It's truly a shortcut to being well-informed, isn't it?
Indeed. And it raises an important question for you to ponder as you reflect on all we've discussed today. Given the detailed checks and balances we've explored and the ongoing evolution of these articles, what do you think is the single most critical constitutional safeguard for ensuring fair governance and justice at the state level in India. Something truly worth reflecting on as you go about your day.
That's a fantastic, thought-provoking question to leave with. Thank you for joining us on this deep dive. Until next time, keep digging for knowledge, because the more you know, the more empowered you become.